So this is State versus Hickman, and both sides will have 15 minutes to present their arguments, and obviously the appellant may reserve up to 5 minutes if you so choose. Just let me know when you start your argument. And also, as you know, we're on Facebook Live, we're being recorded. So we don't like to use any victims' names or any minors' names. I don't think this will be applicable here, but just make sure that you are cognizant of that. Okay, and if counsel are ready to proceed, the court is ready to listen to the argument.
Thank you, Your Honor. Good morning, Your Honors. Judge Carr, Judge Teodosio, and Judge Sutton. May it please the court, I would like to reserve 5 minutes for rebuttal.
Thank you.
Thank you, Your Honor. May it please the court, the issue before this court are as follows. The trial court applied revised code 2919.21B retroactively to Mr. Hickman, violating Ohio law. And Mr. Hickman, issue 2, Mr. Hickman cannot be found guilty of failing to pay an arrearage only order. Issue 3 is amendment to 2919.21B violates ex post facto clause of both Ohio and U.S. Constitution. And issue 4 is the trial court erred in denying Mr. Hickman's motion to dismiss. The issue 1, Mr. Hickman was indicted by the Medina County Prosecutor's Office on May 30, 2019 for violation of 2919.21B. Count 1 of the indictment alleges that Mr. Hickman, on or about the first day of May 2013 through 30th day of April 2015 in the county of Medina, did abandon or fail to provide support established by a court order to DP, date of birth 12/4/1994. And it further goes on to say is that the offender failed to provide support for a total accumulated period of 26 weeks out of 104 consecutive weeks, whether or not those 26 weeks were consecutive. Counts 2 and 3 are identical to count 1, except the period, the 2-year periods are different. Count 2, it runs from May 1, 2015 to April 30, 2017. And count 3 is from May 1, 2017 to April 30, 2019. Your Honors, back in February of 11, 2019, the legislature amended the non-support statute. Prior to that, it read, no person shall abandon or fail to support an established by court order to another person whom by a court order or decree the person is legally obligated to support. On February 11, 2019, they amended it to add additional language saying was legally obligated to support and an amount for support was due and owing prior to the date the person's duty to pay current support terminated and remains unpaid. We are here arguing today is that the trial court applied the amendment retrospectively rather than prospectively.
Counsel, before you get into all of your arguments, while you were going over the indictment, I wanted to ask you a question if you don't care.
Yes, Your Honor.
Because the leading argument I think that the state has made here is that the motion to dismiss the indictment was improper, that it was really more of a motion for summary judgment and you had to look outside the actual face of the indictment. What can you tell us, since you got the indictment there in front of you, what can you tell us in the indictment demonstrates that within the 4 corners of the indictment that this prosecution was improper?
Well, Your Honor, also just not only on that, but I think that the trial court can also go outside the 4 corners of the indictment as stated in Palmer. I think this case is similar to Palmer. In the indictment, it gives the age of the child, DP, 12/4/1994. At the time that the indictment was filed on May 30, 2019, he was already 24 years old. The count 1, it alleges the date between May 1, 2013. At that point in time, DP was 18 years old. So at that time in Ohio, at 18, a child is emancipated. So you can look at it from the indictment.
Well, unless they're still in school and then the support order would go through the school year.
But the court, as Your Honor is aware, most schools here in Ohio is done by June. So that's only 1 month. So by June of 2013, most kids are 18 or graduated from high school. So you could tell from the face of the indictment that he was emancipated. And the orders that they're trying to allege that occurred prior to the termination of his support order. And you can see that from the indictment.
Is there anything, I know there's some discussion about this in a brief, but was there anything in the indictment itself that demonstrated when his support order was terminated?
No, there is nothing in the indictment except for his age. You can determine it from his age that he's 18 already at that time. He would be emancipated under Ohio law, and by finishing high school by June, he would already been completed, and the child support order would have been terminated.
Thank you.
Your Honor, since and so what we're saying is under Revised Code 1.48 provides that any law that is passed there's a presumption of it applying prospectively rather than retrospectively, unless it's expressly stated. We are saying that the amendment does not clearly state so, and it is not. In State v. Concilio, the court stated a statute must clearly proclaim its own retroactivity to overcome the presumption of prospective application. Retroactivity is not to be inferred. Also in Howell v. Porter, it gave you kind of clear examples of what the legislatures are trying to do when they are saying, look, we want this to apply retroactively. They give you examples as this section applies to and governs any action pending in any court on the effective date of this section, and prior to the effective date of this section, if the person was not sentenced for the offense or after. There's no language as such as this in the amendment that took effect in February of 2019. Also, we're saying is that in our second issue is that Mr. Hickman cannot be found guilty of failing to pay child support arrearages only. That was clearly stated in State v. Pittman. In State v. Pittman, the defendant there had a child support order. It was terminated. Years later, happens that the state decided to prosecute him for failing to pay arrearage only. Right? The Supreme Court said it can't do that. It's not a criminal matter. And then recently has been decided in State v. Brown is, well, you can, even though the child was emancipated and the child support order was terminated, the state could still go back and charge somebody criminally as long as the action, or long as the time period there was a valid order. And that was the case in Brown. And Mr. Brown, when he was the indictment alleged that he failed to pay child support prior to the termination. There was no date after his indictment that was alleged in the indictment. And I think that's what the Brown court stated. And it did not rule on the new amendment. It was talking about the old amendment. Our third issue is that if the court decides that the legislature did actually want this to apply retrospectively, we're saying that it violated the ex post facto clause of the Ohio Constitution and U.S. Constitution. Ohio Constitution Article 228, Section 28 states the General Assembly shall have no power to pass retroactive laws. U.S. Constitution Article 1, Section 10 states no state shall pass any ex post facto law. In Beazle v. Ohio, the Ohio Supreme Court stated any statute which punishes a crime as an act previously committed, which was innocent when done, which makes more burdensome the punishment for a crime after its commission, or which deprives one charged with a crime any defense available according to law at the time when the act was committed, is prohibited by the ex post facto law. Also in Collins v. Youngblood, the Ohio Supreme Court, the United States Supreme Court stated, it has been long recognized by this court that the constitutional prohibition on ex post facto laws applies only to penal state statutes, which disadvantages the offender. We think this statute here falls right into those cases. Mr. Hickman's non-payment of a arrearage only judgment happened prior to any amendment to the statute. And it went from a civil judgment where he could be held contempt in court and have an opportunity to purge. And if he doesn't purge, then he'd face jail sentence to a point of now it's a criminal offense. He'd have a felony conviction, be subject to incarceration in prison, not only the local jail. And we believe that this is in violation of the Ohio and U.S. Constitution.
And you have your 5 minutes remaining right now if you would like to stop. It's up to you.
Yes, Your Honor, I would like to rebut for the last part of which is the state's initial argument regarding the face of the indictment. Thank you, Your Honor.
Thank you. Thank you. For the state? You need to unmute yourself. Thank you.
Good morning, Your Honors, and may it please the court. I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the state of Ohio. I will begin with the assignment of error number 4 on the question of the dismissing the motion to dismiss, because that question is dispositive. As Judge Carr said, it was not proper at that point.
Well,
it was essentially
Mr. Vellucci, I don't think Judge Carr said it wasn't proper, but go ahead.
Well, yeah. As you raised the concern, certainly about it being similar to a motion for summary judgment, and that's exactly what it is, because it's introducing and what was being done here by Mr. Hickman was introducing factual evidence outside the 4 corners of the indictment. And that's why the trial court dismissed this, or denied, I should say, this motion to dismiss the indictment properly in this case without reaching the underlying merits of the case in terms of whether this is retroactive. And the state certainly has a position on that as well.
But counsel, from the face of the indictment, it has the date of birth of the child, and all the dates are after his 18th birthday. So there was no existing support order, present support order that he was indicted under. It was all for arrearages when he was under 18, right?
No, first of all, I would mention first that even if you agree with everything that Mr. Wan is arguing here, and we strongly disagree with all of it, but the only count that would fail in that scenario would be count number 2. Count 1 and count 3, we argue, would still survive, because that period, so there's 3 different 104-week periods that make up these 3 counts. Part of that first 104-week period occurred before the juvenile was emancipated. And part of the last 104-week period happened after the February 11th, 2019 amendment happened. So we would argue, even in that scenario, 2 of the 3 counts survive. Now we to go back to the date of birth issue, that is not the relevant point here. The point is when the child support entry, the termination of the child support obligation actually occurred from court. Just by the child turning 18 does not mean that's the date that this thing terminated. And that's how you determine what's arrearage and what's not. So to determine that, to determine whether and when all of these were arrearage only, you had to have that child support termination judgment entry from the domestic relations court. And that's factual evidence that was outside the face of the indictment. And that was the only way you could know that June 9th, 2013 date, that was when the support order was terminated. You can't just imply all those things from a date of birth in terms of when the child actually turned 18.
Well, why couldn't you do the simple math and say, 18 years from date of birth is June 9th, 2013.
Well, because that would be incorrect. In this case, I believe the date of birth listed is December 4th, 1994. So if you did that math and you just assumed that the child support order had been terminated exactly 18 years from December 4th, 1994, that would be incorrect, because in reality, the order was terminated on June 9th, 2013. And that's the date when anything after that became arrearage only. So that's why you can't do that. And you need that factual evidence, which is outside the indictment, to know what's arrearage only and what's not.
Is there anything in the record that actually does provide for his the termination of support, the actual date? I know you just gave it, but and the other side gave it too, but
Mr. Wan attempted to introduce that document with his motion, and we objected to it, and we argued that it was improper for the court to consider it, and the court agreed that they were confined to that he was confined to the four corners of the indictment, and that was correct in our view. In terms of the Palmer decision, that Supreme Court case that Mr. Wan mentioned, that case is distinguishable in terms of because we would say the Palmer case actually was decided based on just the four corners of the indictment. They were not looking outside the indictment. Palmer was an Adam Walsh Act case. The defendant was indicted for violating his registration requirements under the Adam Walsh Act, but the offense had occurred before the Adam Walsh Act was effective. So the Supreme Court of Ohio, just the previous year from Palmer, in the Williams case, had decided that the Adam Walsh Act could not be applied retroactively to offenses committed before its enactment. So in Palmer, it could be determined just from the four corners of the indictment, the date that the state was saying that the failure to register offense occurred. And it could also be determined from the face of the indictment that the defendant was being charged under the Adam Walsh Act, and it could be determined the date of the alleged offense was prior to the effective date of the Adam Walsh Act. So then it was just a simple matter of applying the Williams decision that the Adam Walsh Act can't be applied retroactively.
But counsel, why couldn't the court have done that in this circumstance? Because all of the dates are prior to the amendment to the criminal non-support statute of 2019. So the court could have looked at it just on the face of the indictment and said whether it was retroactive or not. The court could have dismissed the indictment, couldn't it have?
No, I don't think so, because it had to know what was arrearage only and what wasn't, and it couldn't know that without that additional factual evidence. And I would just add that the third count, part of the third count actually does happen after the indictment. So I would say it's not all retroactive. We don't have to rely on retroactivity for all of it, but I would say this case is certainly different than that case in that respect, because there was additional evidence that you couldn't just take judicial notice of, essentially. I will move, just in case that this court does decide to get to the merits of the underlying issue in terms of whether this is retroactive. The state does have a position on that, and it's that certainly this statute is retroactive, and it was designed by the legislature to be retroactive specifically. There was some suggestion by Hickman, and I want to address this as well, that when he pled no contest, that the trial court should not have found him guilty then. Well, that's incorrect. The trial court had to find him guilty after he pled no contest. In this case, this court, Supreme Court of Ohio, have held that where an indictment contains sufficient allegations to state an offense, the defendant then pleads no contest, the court must find the defendant guilty of the charged offense.
Well, what about, was there any recitation of facts?
It was no, I don't believe so. And
Did the defendant waive the recitation of facts?
no, but I believe it was very. There was an argument that took place. It was a brief argument by Mr. Wan at that point. But in terms of so I believe the court absolutely had to, because it stated, the indictment stated validly an offense. So at that point, you couldn't just say, no, I'm not going to accept this, and I'm not going to then find him guilty. Again, the state does believe that the amended non-support statute applies retroactively for several reasons. In this case, the General Assembly expressly made the statute retroactive when it used the phrases "was legally obligated to support" and "was due and owing" prior to the date the person's duty to pay terminated. Mr. Wan mentioned the Concilio case, and they stated it, and that's another case that's distinguishable from this case. That was a case dealing with DNA and the requirement to provide DNA. And they said it was not retroactive in that case. And they said, because the language in that case was in the present tense. And that's why that's distinguishable from this case as well. The court noted in that case that a statute that uses operative language in the present tense does not purport to cover past events of a similar nature. Well, if that's true, then it must follow that a statute using operative language in the past tense does purport to cover past events of a similar nature.
Well, counsel, why isn't the statute just written that way in the past tense, so the legislature wanted to make sure that arrearages were covered, because that was past support. So what is in the statute besides "was legally obligated to pay" that demonstrates the retroactivity of going back for child support that was owed in the past that is now in arrearages?
Well, Your Honor, we would say that's enough, and that's very compelling in itself. And if you look at a case like Caldwell out of the 1st District, that's really on point here, we think, in terms of retroactivity. And I think it's very persuasive for this court to look at the Caldwell case, 2014 Ohio 3566. That case involved a 2013 amendment to the arson offender registration statute. And Caldwell there was arguing that the amended statute could only be applied prospectively, because he said there wasn't any clear language of retroactivity, I guess, such as, this statute shall be retroactive. Well, you don't need that, and you're almost never going to see that. So the 1st District noted simply that the amended statute's language incorporated criminal conduct that occurred before the statute's effective date. It's the same thing we have here. Therefore, the court held the statutes were retroactive.
But in our case before the court today, the conduct before 2019 was not criminal unless there was an existing support order. There had to be an existing support order before 2019 in order to find somebody guilty of criminal non-support. Would you agree with that?
Well, after Pittman, that that was the case. So in that short window, I guess, in those couple of years after the Pittman decision, yes, that had become the case. And in terms of Pittman, it's widely known that the legislature passed that Senate Bill 70 in 2018 in direct response to the Pittman decision to close that loophole, to make sure that arrearage only could be prosecuted.
Right. So what I guess I'm wondering is, was legally obligated to pay? Couldn't that be argued that that just actually created the criminal offense on an arrearage, and not that the legislature intended that to make it retroactive?
We would say they did intend to make it retroactive, and they made it a criminal offense, but but what's interesting in terms of when you look at the ex post facto part of this, why it's not ex post facto, it's remedial and not substantive. They didn't actually increase the punishment. The punishment section was kept unchanged in it. And it's also important, a new right was not created and an old right was not taken away. Child support obligees have always had the right to be paid arrearages. It's just that after the Pittman decision, the remedy had become confined to civil contempt in DR court, which of course can also result in incarceration, as Mr. Wan mentioned. The Supreme Court of Ohio has held that the commission of a felony is not a past transaction that creates a reasonable expectation of finality.
And counsel, I have to tell you, you really are out of time now. If you wouldn't mind summarizing. I'm sorry, I was asking you so many questions. I apologize.
Sure. Yes. And in terms of the Brown decision, just briefly, I would say that actually.
Well, counsel, you just need to summarize.
But the state of Ohio just would respectfully ask that this court affirm the judgment of the trial court. Thank you.
Thank you very much. And Mr. Wan, you still have 5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. Your Honor, just briefly to touch on the face of the indictment. It's not per se that just because if you have to go outside the indictment that you are not allowed. I mean, Palmer says you can. If in the Palmer cases, they're having a gentleman who's under sex offense register when he shouldn't have to register. And Mr. Vellucci is saying as well, they could tell by the face of the indictment when it happened. But in the indictment, it doesn't say this Adam Walsh Act was enacted on such and such a date. It says you violated a certain act, and this is the time period that you violated this act in, just like in the indictment in Mr. Hickman's case. And so we're saying is you can, if you decide to go out, so the indictment, you are allowed to go out. Palmer says to go out. If
Mr. Wan, I have to ask you the tough questions, just like I asked Mr. Viglucci. I can never say your name. I apologize, Mr. Viglucci. And that is that in the Palmer case, the law is the law. So the Adam Walsh Act was enacted, and the court always can look at the law. But what you're asking for is the court not to just look at the law, but to actually look at another court order from a different case, from a different court, I should say, about termination of child support. And isn't that a completely different issue?
I don't think they didn't just look at the law only itself, because it says, well, here's what the law said. And he said is, look, I was convicted, I served my time and everything was done. I wasn't sentenced and I wasn't required to register under the old law. So they still had to go back and look at that and say, well, right. And when was his conviction? When did that happen? When did this law pass? And so it's the same situation as here is when did the time period they're alleging occurred? When was the amendment enacted? It was prior to this. So you can go back and say, well, you're trying to go back and get somebody who did not do anything wrong, and now saying, well, you did something wrong. It's kind of like saying, okay, well, you can't wear a red hat today, right? And if you wear a red hat today, we're going to hold you in civil contempt. And then 6 years from now, well, since you wore a red hat today on that day, we made a law now saying that's a felony. Well, we're going to go back and say now it's within the 6 years. We're going to charge you with a felony. I think that's similar in this case, and it just doesn't seem that you know, the law should be allowed to go back and punish somebody for something that they did back then that wasn't punishable by going to prison and getting a felony conviction. I know Mr. Vellucci keeps on saying, you know, if you know, felony if you're a felon, but Mr. Hickman was not a felon prior to being sentenced or by prior to pleading no contest to this charge. He was not a felon for non-support at that time when this indictment came out. We believe that is that, you know, the court can go outside the indictment, and the court should go outside the indictment if you couldn't determine from the face of the indictment. We think you could still determine from the face of the indictment that it was defective. But if you couldn't, then I think you could still go outside the indictment and look and say, look, the child was clearly emancipated. The termination order was clearly happened. So are you going backwards or are you going forward, right? And so if you're going backward, and I think the court should be able to decide, well, did the legislature clearly say we want to go back and be retrospective, or if not, are they applying it unconstitutionally? If the legislature did so, then the court could take another step and go is, well, does that violate the ex post facto law? And I think the court could have done that, and it didn't do that. And in the transcript, if you read the transcript, is the court clearly stated, you know, this is going up to appeal. The state agreed that it's going to go up to appeal, that this has to be decided by the appeal court. And I don't think it was just on the face of the indictment, because we made the argument in the transcript is, look, we're making that the law is being applied retrospectively rather than prospectively. Those were in the transcript on page 7 of the transcript.
What about count 3, that 3-month period from February to April after the effective date? Why would that not be a valid conviction?
Well, Your Honor, in the Brown case, it clearly states that, you know, yes, you can go back and you can look at if the action occurred before the termination, but you still have to meet the statute of limitation and all the elements of the crime. And the elements of the crime of non-support is 26 weeks out of a 104-week period. 3 months is not a 104-week period.
Thank you.
Counsel, with that, your 5 minutes of rebuttal time are expired.
Thank you, Your Honor.
Thank you, gentlemen. I appreciate both of you presenting your arguments to the court today. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we will release it electronically.